Turmoil in Castle Hills.
Charged with a misdemeanor.
City council people taken into custody.
My name is Sylvia Gonzalez, and I was born and raised in San Antonio, Texas. I moved to Castle Hills in 2001. I decided to run for my seat on Castle Hills City Council because I had the time and the energy to work. I got a very good response. I went to more than 500 residents. They complained bitterly about the city and that they could not even get a hold of anyone because the city manager would not return their calls. Their streets were not being fixed. They're my neighbors.
We'll see you later.
That's what they talked about. They were glad to see someone that was going to finally be able to do something for them. And I won.
Please raise your right hand and repeat after me.
By 53% of the vote.
Of this state, so help me God.
And of this state, so help me God.
Congratulations.
And I only tried to do my job and represent them.
Sylvia was obviously troubled by the concerns that her neighbors raised to her while she was campaigning. And actually, one of the people she met with suggested that Sylvia spearhead a petition to raise these issues with the city council.
One of my supporters came up with a petition. I felt the petition was important because it gave my word a lot of strength.
This was just an act of pure political expression. The petition itself was not binding. It had no legal effect. It was just meant to symbolize how things were being run at the city. By the time Sylvia actually attended her first city council meeting, the petition had been gathered and was ready to be submitted to the city.
My first council meeting, we were assigned to evaluate the city manager. You can share them now.
Objection.
Because of all the turmoil and the hostility, they can never get you to return any calls. Lasted till after midnight. Please don't interrupt me. At the end of the second day, the second meeting, I just had all these papers, so I tried to gather them, and then I tapped them on the desk. And then I just stuck them at the top of my binder. The Castle Hills police captain comes over, taps me on the shoulder, and tells me the mayor wants to speak with me. I go over to the mayor, and he asks me where is the petition that was turned in. And I told him I didn't know where it was. He proceeded to tell me that he thought it was in my binder, that he could see a little clip. And I found the petition, to my surprise, and I handed it to him, and he said, "You probably picked it up by accident." And I thought nothing of it, but I was thrown in jail.
A couple days after the meeting, the police chief spoke to another officer and let him know that the mayor was expected to file a criminal complaint against Sylvia for allegedly having tried to steal the petition that she herself had championed. The police chief turned to a trusted friend, a local attorney named Alex Wyatt Wright, to investigate Sylvia. He determined that the best charge was under a misdemeanor statute for tampering with a government record.
I went in and got handcuffed, I got frisked. They wanted me to put on this orange shirt, but I was cold and I had to sit on a metal chair. It was a very hurtful experience. And the sad part is I did nothing wrong.
The city's goal in having Sylvia arrested was to send a message both to Sylvia and anyone like her who might speak out against the way the city was running things.
I believe they were upset with me because I was trying to represent the people that I spoke with, the residents, on what they wanted. And that's why the petition was sent around. I really wanted to work hard and make that happen.
The First Amendment guarantees the freedom of speech and the right to petition the government. The government and its officials cannot then turn around and retaliate against that person in any way. And certainly that includes arresting someone and charging them with a crime.
I was hoping that the Institute for Justice would help me.
IJ's standing with Sylvia to vindicate her First Amendment rights, because a right without a remedy is no right at all. And if any of us hope to enforce the Constitution against the government officials that it restricts, we have to ensure that constitutional violations are met with remedies that are provided in the courts of this country.
Today on Legalese, we are talking about the case of Gonzalez v. Trevino. Hey, greetings everybody, and welcome back once again to Legalese. As always, I'm your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, if you want to find out more about the show, you can go check out our homepage over at legalespodcast.com. And if you want to get up to date and get notifications whenever I post any new content, and I don't just do these videos on YouTube, I write articles on Substack. There's an audio-only version of the show. And if you want to get notifications for all of those things, or just some of those things, get it curated, either way, all you have to do is go over to legaleshow.com where you can subscribe to our newsletter, and you can get that sent right to you. And I would recommend doing that because the subscribe and notification button on YouTube isn't doing a lot. I have gotten several complaints from several subscribers who are telling me that they are not getting notifications when I put videos out. So I don't know what that is, but that may be, even if you just watch me on YouTube, that may be a good reason to go sign up for the newsletter. All right, well, we've got a lot to get to today, so let's just jump the fuck right in. So, as I mentioned off the top, today we are talking about the case of Gonzalez v. Trevino, and it looks like we have a bit of catching up to do on this case because despite the fact that I have been following this case personally since it came to the Fifth Circuit, and despite the fact that, as you can obviously see here, this case is one that I added to my caseload for this term for my Supreme Court roundup. When I went back to my videos and articles from October that I did about the cases on my list, which I always do, just to look and remind myself, you know, what precisely have we discussed about this case already? What have we not? And as I started trying to look for that information, I couldn't find any discussion of it whatsoever. It appears as though I somehow completely overlooked doing a primer on this case. So this is, well, it's a little frustrating, to be honest. This case is one that deals with so many topics that are really sort of at the heart of the content I do here on this channel. So this case is going to be a landmark, absolutely, in First Amendment jurisprudence and potentially Fourth Amendment as well. It also involves a healthy amount of constitutional construction as it comes to both the First and Fourth Amendment, as this case addresses aspects of those amendments that are, while they're not uncommon to be dealt with in the lower courts, a lot of this is breaking completely new ground before the high court. And furthermore, this case deals with a lot of issues of great importance to me personally, and I'd be willing to bet probably to most people who follow my content. And so this includes issues such as government corruption and unjust legal immunity doctrines. The first of these is the well-known qualified immunity, but the second one is one that is probably going to be completely unknown to most people, and this is what is known as the independent intermediary doctrine. And the reason is that this doctrine has been adopted at the Circuit Court of Appeal level, except for the First Circuit. But every other Circuit Court of Appeals has accepted and applied this doctrine. It also gets an extremely inordinate amount of attention from the Fifth Circuit specifically. And this case just happens to be coming to the court out of the Fifth Circuit. However, the Supreme Court has not ever touched this doctrine because it ignores congressional intent and proximate cause principles, that existed at the time of the Civil Rights Act when it was created back in 1871. This is the law that remains on the books today as the familiar 42 USC section 1983, which is the relevant statute to qualified immunity, because this statute creates a cause of action for deprivation of rights by a government official under color of law. So as I said, today is going to be our primer video. I will be providing you with a breakdown of the background events in the case as well as the facts of the case. We'll be looking at its procedural history in the lower courts and the merits of the case as it is coming before the Supreme Court. And then our next video will be a review of the oral arguments that were actually just heard last week on March 20th. And then after that, there will almost certainly be another video or two where we will be exploring some of the more important related topics sort of as their own videos, such as talking about those different immunity doctrines. But let's start here today by looking at the background and facts of the case. So this goes back to about 4 years ago when Sylvia Gonzalez was a newly elected member of the Castle Hills, Texas City Council, when she would be charged with concealing a government record, which is a misdemeanor that would have resulted in her removal from office had she been convicted. Now, the Bexar County District Attorney, Joe Gonzalez, who is of no relation to Sylvia Gonzalez, declined to pursue the case, and as we get into it, it will not be hard to see why. Now, this charge was orchestrated by Sylvia Gonzalez's political opponents based on what she describes as an honest mistake. After a city council meeting, she says she accidentally picked up a bundle of papers that had been strewn across the table in front of her. One of these was a petition against the city manager, Ryan Rapley. This was a petition that she herself had organized, and she had apparently placed this petition along with some of her own papers into her binder. Now, as a result of this, Gonzalez was arrested 2 months later and spent a day in jail, after which her mugshot would appear in a local news report. Now, in this case, Gonzalez is being represented by the good folks over at the Institute for Justice, and their homepage contains, as they always do when they take a case, a treasure trove of information. This is where I got that mini documentary video that I started this video from. It's where I got a lot of my own research from. And so if you want to find out more about this case, get the court records, watch interviews with the involved parties, or if you want to donate to Sylvia Gonzalez's Legal Defense Fund, you can find all of that information on her website with IJ, which will be linked in the show notes for this episode. And according to the Supreme Court petition that IJ filed on Sylvia Gonzalez's behalf in April, quote, Gonzalez was so hurt by the experience and so embarrassed by the media coverage of her arrest that she gave up her council seat and swore off organizing petitions or even criticizing her government, end quote. Now, Gonzalez would file a petition for cert on April 20th of 2023, seeking review from the Supreme Court, and on October 15th, the court would grant cert, and they would add Gonzalez v. Trevino to their docket. Now, at the heart of this case is a question as to what counts as objective evidence that someone was arrested in retaliation for constitutionally protected activity. Now, the circumstances of Gonzalez's arrest leave little doubt that she was a victim of a trumped-up charge provoked by her political activity. So she is a 72-year-old retiree who won her seat on the city council in 2019 after campaigning on a promise to seek city manager Ryan Rapley's replacement. Now, toward the end of that campaign, she would organize a petition that a resident would present to Mayor Edward Trevino on May 21st of 2019 at the very first city council meeting that Sylvia Gonzalez would attend. The ensuing debate here about Rapley's performance continued into a meeting the next day, during which Gonzalez was sitting next to Mayor Trevino, who, as the mayor, presides over their city council meetings. And after that, according to Gonzalez, she quote, picked up the papers strewn around her sitting area and put them in her binder, end quote, which she left on the table as she would cross the room to go converse with a constituent. Now, she says a few minutes later, a police officer in charge of safety at the meeting would tap Gonzalez on the shoulder, explain the mayor wanted to talk to her. The police officer would escort Gonzalez to the mayor, who was still in his seat next to Sylvia's. Mayor Trevino would ask Gonzalez where the petition was. She would respond asking him, "Don't you have it? It was turned into you yesterday." And at the mayor's prompting, Gonzalez did look for the petition in her binder, and to her surprise, she found it there. She handed the petition back to the mayor, who volunteered to Sylvia that he was sure she had probably just picked it up by mistake. But this was not the end of the matter. Now, Mayor Trevino and their police chief, John Seaman, are both, political allies of Ryan Rapley, and they used the briefly missing petition as a pretext for a criminal investigation into Sylvia that took 2 months. And 2 days after the meeting in question, the police chief would inform one of his officers that the mayor would be filing a complaint against Sylvia. When the officer's investigation went nowhere, Seaman would deputize an attorney and personal friend of his, a man named Alexander Wright, to take over as a special detective. And 1 month later, Wright would file an arrest affidavit that would charge Gonzalez with violating Section 3710A3 of the Texas Penal Code, which applies to someone who intentionally destroys, conceals, removes, or otherwise impairs the verity, legibility, or availability of a government record.
How about that? I looked something up. These books behind me don't just make the office look good, they're filled with useful legal tidbits just like that.
Now, this charge is implausible on its face, since it implied that she was hiding the very petition that she had worked so hard to produce and present to the mayor. And the affidavit itself would, oddly enough, cite Sylvia Gonzalez's agitation against Ryan Rapley as evidence of her committing this offense. So, turning to the arrest affidavit itself, it says defendant Gonzalez was, until July 9th of 2019, serving as an alderwoman for the city of Castle Hills, Texas. From her very first meeting in May of 2019, she, along with another alderwoman, had been openly antagonistic to city manager Ryan Rapley, wanting desperately to get him fired. Part of her plan to oust Mr. Rapley involved collecting signatures on several petitions to that effect. Now, in that affidavit, he would complain that Gonzalez had visited a resident's house to get her signature on one of the petitions under what he calls false pretenses by misleading her and telling her several claimed fabrications regarding Ryan Rapley. And furthermore, the affidavit purports to assign signals of guilt and intentional concealment of the document that simply cannot be deduced from watching the footage and analyzing her gestures as being indicative of either guilt or intent. So, according to the affidavit, at the 4-minute and 6-second mark in the footage, Gonzalez appeared to be purposefully avoiding finding the petition by feigning her failure to notice the obvious binder clip, which those around her could clearly see. Also, she moved extremely slowly while looking through her 3-ring binder, only thumbing through a few pages at a time, much more slowly than someone would do if they were trying to prove they didn't have the petition. It seems as if she was wasting time, hoping for some form of rescue. Now, this is absurd to conjecture how someone trying to prove they didn't have the petition would have acted. This statement demonstrates obvious signs of bias by reading every action with the presumption, taken as a given, that she must have been trying to steal this document. My question is, why would she feel the need to prove anything? Even if we assume that his allegation that she was trying to take the document might be true, based on the facts available to them at the time. It's equally possible her claim that it was put into her binder as an honest mistake is equally likely to be true, in which case Sylvia would not have been trying to prove she didn't have it because she hadn't been accused of stealing the document. The mayor had simply asked her to look in her binder for the petition. The exchange that took place between them was in no way accusatory. And again, this is all on videotape. I've seen the videotape myself. You can see it over at the Institute for Justice. And even after Sylvia found the petition, the mayor reassured her that he was sure this was all just some honest mistake. Now, again, having watched this video myself, I have gone to that precise portion, the 4-minute, 6-second mark, and watched that. And my distinct impression was that she was just humoring, essentially, the mayor's request and appeared to be sort of half-assedly looking for documents that she just genuinely didn't expect to find because this was, as she claimed, an honest mistake. And herein lies the problem.
But all I did was tell the truth.
Of course you did, but there's the truth and the truth.
Now, I will grant that the interpretation in the affidavit was not unreasonable, but neither is my interpretation, which highlights the problem of accepting evidence such as a transcription of a video that purports to provide subjective evidence of intent. Especially considering that, as far as I could tell, the judge who signed the warrant never actually watched the video for himself and appears to have accepted the transcription prima facie, including the conjecture and the subjective, and some might even say biased, interpretation of its context.
Do you have any evidence at all?
Well, Your Honor, we've got plenty of hearsay and conjecture. Those are kinds of evidence.
And all of this segues into another troubling aspect. This has to do with the issue of the warrant itself for this offense, which goes against the common practice in Bexar County for a nonviolent misdemeanor. Yet, Wright sought an arrest warrant, and instead of referring the matter to the district attorney's office, Wright would present his affidavit directly to a judge. Now, this is a procedure that is generally reserved for emergencies or violent felonies, because this meant that the warrant wasn't in the satellite booking system, so Gonzalez could not be booked, processed, and released without spending time in jail. Now, that is why Gonzalez, who would turn herself in as soon as she learned about the warrant, ended up spending a whole day behind bars, apparently handcuffed on a cold metal bench, wearing a jail shirt, avoiding the restroom, which has no doors on it. Now, Gonzalez, the district attorney Gonzalez, not Sylvia Gonzalez, the district attorney, who again was in no way related to Sylvia, would drop the charges as soon as he learned about them. But nevertheless, this achieved what Gonzalez says was their goal all along, which was to simply try to drive her out of office. And that these allegations, according to Sylvia, were never about fairly enforcing the law, but instead were a pretext to chase her. And this is further supported by the fact that this was not the first, nor would it be the last attempt to harass her into resigning by these Castle Hill incumbents whose interests lay with protecting this unpopular city manager. Now, what do I mean when this wasn't the first or the last thing that would happen? Well, within weeks of her winning election, the harassment would begin. First, the city attorney, who was also aligned with the mayor and the city manager, claimed that Sylvia wasn't properly sworn in.
What are you basing that on, Mom?
Who wants ginger snaps?
Now, there's no evidence this is true, and it doesn't explain why they wouldn't have done what literally any other person would have done in this situation, which would be to simply administer the oath of office to her again. Now, what you don't do is use that claim to simply give her seat on the city council to the person who ran against her and lost the election.
So, people are really used to this flavor. And you know what else they're used to? They're used to taking it in the ass. As in, they pay taxes and they get that water and they do nothing about it. They might scream a little bit and say, oh, our water's bad, but they end up not doing very much, so it doesn't really matter. So I like to emulate that sort of, that sentiment of paying taxes, paying really high taxes and getting nothing in return, not even clean water.
But that's what Castle Hill decided to do. They replaced her on the city council with the woman she had just beaten. And Sylvia had to go to court and get a legal order from a judge to get reinstated into the office into which she was democratically elected. And finally, after beating back the city, a group of citizens who were very much aligned with the mayor would file a lawsuit claiming Sylvia was incompetent. Again, Sylvia stood her ground and she won. But by this point, she says the damage had been done. Her mugshot had been splashed across the news, her reputation dragged through the mud, and she was, at this point, already exhausted, already dealing with tens of thousands of dollars in legal bills, and at this point she would stop trying to fight to reclaim her seat. And with that, let's look at the procedural history of this case in the lower courts. So, looking at what exactly was she charged with? Well, Sylvia was arrested for, quote, destroying, concealing, removing, or otherwise impairing the verity, legibility, or availability of a government record. Now, the mayor and his allies allege that Sylvia's temporary possession of her own petition fell within the broad reach of this statute. But an analysis of the county criminal record shows that no one in the 10 years prior to Sylvia's arrest had been charged with that crime for doing something similar to what the mayor and his allies alleged against Sylvia. Still, they would secure a warrant for her arrest, and though she had never so much as received a speeding ticket in her life up to this point, this 72-year-old woman who looks like she could be anyone's grandmother was booked into jail for doing nothing wrong, really. So in September of 2020, a complaint was filed by Sylvia with the U.S. District Court for the Western District of Texas. In it, Gonzalez says that Trevino, Siemens, and Wright had violated her First Amendment rights by orchestrating her arrest in retaliation for her opposition to Ryan Rapsley. She notes that the statute had never been used to arrest a person in an analogous situation. Now, in addition to this county data, Sylvia would amplify the alleged facts by showing her arrest was retaliatory by providing such evidence as the following. First of all, the mayor and the police chief assigned a friend and local lawyer as a special detective to investigate Sylvia after two regular police officers looked into the situation and declined to charge her with any crime. Second, the special detective went around the local prosecutor, who would later dismiss the charges. Third, the special detective deviated from the normal process by seeking an arrest warrant and ensuring that Sylvia would have to actually spend time in jail. Furthermore, the special detective's affidavit supporting the warrant specifically identified Sylvia's speech as being critical of the city manager, and that another ally of the mayor had published an article in the city newsletter outlining how a city council member could be removed from office if convicted of a crime. Now, the mayor and his allies would in turn file a motion to dismiss under Rule 12b-6 under the claim that they were entitled to qualified immunity. And Rule 12b-6 is failure to state a claim for which relief cannot be granted, or for which relief can be granted. Failure to state a claim for which relief can be granted. Now, as I'm sure regular listeners to the show know, qualified immunity is a doctrine that shields government officials from being held accountable in court for purely technical reasons. not because they didn't violate an individual's constitutional rights. Now, while qualified immunity is usually a difficult hurdle to overcome, the district court would, very much to their credit, deny protection to the mayor and his allies, and writing, the court finds that, viewing the facts in the light most favorable to the plaintiff, the individual defendants violated the plaintiff's constitutional rights. Plaintiff alleges that she was arrested because she organized a non-binding citizen's petition, not because she attempted to then steal her own petition. She claims that the individual defendants acted with a retaliatory motive by alleging that they took several actions to attempt to take away her council seat. The court goes on to say these allegations support the existence of a retaliatory motive and causation. As described above, even if there were probable cause to arrest the plaintiff for the misdemeanor, the exception in Neves applies because she had pled the existence of objective evidence that she was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. Now, you may be asking yourself after that last paragraph, what is the Neves exception? Well, in this case, the defendants would argue that Sylvia Gonzalez's First Amendment claim was barred by the existence of probable cause for her arrest because of the Neves exception. Now, this comes from a 2019 case of Neves v. Bartlett, a Supreme Court case, and there a Russell Bartlett was arrested by Alaska State Trooper Louis Neves and Brian Waite for disorderly conduct. He sued, claiming, among other things, retaliatory arrest. And the Supreme Court held that if an officer has probable cause to arrest someone, retaliatory motive is irrelevant. A First Amendment claim is not available at all, but in Neves, the court held that a plaintiff could prove retaliation even when the arrest was based on probable cause if he could present objective evidence that he was arrested when otherwise similarly situated individuals not engaged in the same protected speech had not been. Now, the Neves exception is referred to as the jaywalking exception based on the majority opinion in which Chief Justice John Roberts would use a jaywalking example to illustrate the exception. So he said, for example, at many intersections, jaywalking is endemic but rarely results in arrest. If an individual who has been vocally complaining about police conduct is arrested for jaywalking at such an intersection, it would seem insufficiently protective of First Amendment rights to dismiss the individual's retaliatory arrest claim on the grounds that there was undoubted probable cause for the arrest. Now, in a partial concurrence, Justice Neil Gorsuch would underline the reason for rejecting a blanket rule that blocks a retaliation claim where there is probable cause for an arrest. So he says, history shows that governments sometimes seek to regulate our lives finely, acutely, and thoroughly and exhaustively. In our own time and place, criminal laws have grown so exuberantly and come to cover so much previously innocent conduct that almost anyone could be arrested for something. If the state could use these laws, not for their intended purposes, but to silence those who voice unpopular ideas, little would be left of our First Amendment liberties, and little would separate us from the tyrannies of the past or the malignant fiefdoms of our own age. The freedom to speak without risking arrest is one of the principal characteristics by which we distinguish a free nation. Now, Sylvia's lawsuit would argue that the city officials had charged Sylvia under a statute that has never before or since been used to arrest an individual similarly situated to Sylvia. And this was why the district court found the exception in Neves applies here, because she had pled the existence of objective evidence that she was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. Now, the mayor and his allies would appeal the district court's denial of immunity to the Fifth Circuit Court of Appeals, which would reverse over a blistering dissent from Judge Andrew Oldham. In turning to the majority opinion, the Fifth Circuit would hold that Gonzalez cannot take advantage of the Nieves exception because she has failed to present objective evidence that she was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. Gonzalez does not offer evidence of similarly situated individuals who mishandled a government petition but were not prosecuted under Texas Penal Code Section 3710A3. Rather, the evidence she offers is that virtually everyone prosecuted under Section 3710A3 was prosecuted for conduct different than hers. They go on to say, the inference she asks us to draw is that because no one else has been prosecuted for similar conduct, her arrest must have been motivated by her speech. But the plain language of Nieves requires comparative evidence because it required objective evidence of otherwise similarly situated individuals who engaged in the same criminal conduct but were not arrested. The court finds that the evidence Gonzalez provides here comes up short. So in effect, the Fifth Circuit is holding that in order to defeat the city official's motion to dismiss her lawsuit, Sylvia needed to supply specific evidence of another Castle Hills City Council member misplacing a citizen's petition who didn't criticize the city manager and was permitted to walk free. And it is only that impossible standard of evidence that could prove that Sylvia's arrest was retaliatory and nothing less. As mentioned, there was a great dissent in this case by Judge Andrew Oldham, who thought Gonzalez had met the Nieves test. Of her evidence, she says, first, Sylvia's evidence is obviously objective. She did a comprehensive review of the misdemeanor and felony data of Bexar County over the past decade, and she doesn't rely on the statements and motivations of the particular officials, which I think is a direct dig at that arrest affidavit that was filed by the city that was just full of clearly biased conjecture. Now, Judge Oldham goes on to say, second, Sylvia's evidence supports the proposition that Nieves requires she was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech or conduct had not been. Evidence that an arrest has never happened before, i.e. a negative assertion, can support the proposition that there are instances where similarly situated individuals not engaged in the same protected activity hadn't been arrested. Context determines whether a negative assertion amounts to positive evidence. And Judge Oldham would also question whether the Nieves test made sense in this context. That rule was, of course, meant to accommodate the necessities of a split-second decision to arrest, according to him, and he goes on to say, it is unclear to me why we should apply a rule designed for a split-second warrantless arrest to a deliberative, premeditated, weeks-long conspiracy. Now, following this Fifth Circuit decision, Sylvia would petition the court to hear her case, and while this case does arise from a qualified immunity appeal, the issue of qualified immunity is not directly before the Supreme Court. Rather, the court will decide whether, and if so, how a victim of retaliatory arrest can bring or prove a First Amendment claim and hold government officials accountable for their misconduct. And specifically, the Supreme Court will be considering two questions. First is whether the Nieves probable cause exception can be satisfied by objective evidence other than specific examples of arrests that never happened. And the second question is whether the Nieves probable cause rule is limited to individual claims against arresting officers for split-second arrests. All right, well, that is all I have for you guys here today on Legalese. Thank you so much for joining me. Now, if you would take a moment and do all of those things that help to trigger Al Gore's rhythm, I would greatly appreciate it. If you liked it, hit the like button. If you disliked it, hit the dislike button. go ahead and subscribe to the channel so you hopefully get notifications when new content comes out. It sounds like that's maybe not happening as much as it should. I'm trying to figure that out, but yeah, better to subscribe and be safe. Click that bell so you get notifications. Please leave me a comment. I really do enjoy getting your guys' thoughts on these videos and this content. Just let me know what you thought about the case or this video, or whatever you want to talk about. And take a moment, please, if you would share the show with someone. If you would just quickly before you go, share this episode out to your social media, or just think of 1 or 2 friends you know who would find this material interesting or useful. Send it to them. That is a really great way you can help me grow the channel for free with very little effort, and I would be very grateful. So we will be back in a couple of days doing a deep dive into the oral arguments in this case, and so until then, this has been Bob for Legalese, talking about Gonzalez v. Trevino, and of course, as always, Cartago delenda est.
Motherfucker, like Freddie Mercury.